Welcome. You're diving in with us again, and you know we aim to cut through the noise and get to the heart of things. Today, we're tackling a Supreme Court case that might seem like ancient history, Baker v. Carr from 1962, but trust me, it's the bedrock for so many of the big fights about voting rights we're still seeing today.
Absolutely. Think of Baker v. Carr as the moment the Supreme Court asked itself a really fundamental question. Should federal courts even be allowed to look at how states draw their political maps? For decades, the answer was a pretty clear hands-off. It was seen as a political question best left to the states.
Okay, political question. Let's unpack that a bit. It sounds like the courts were basically saying, this isn't our area. This is for the politicians to figure out, right? Like they wouldn't typically step in if Congress was debating a new law, for example.
Right.
State legislative districts were considered in that same realm.
That's a helpful way to think about it. The established understanding, particularly after a case called Colgrove v. Green back in 1946, was that the Constitution didn't give federal courts the authority to second-guess how states organize their own legislatures. It was seen as, well, a core political function of the states.
But here's where things get really interesting, and where the need for Baker v. Carr becomes clear. Picture Tennessee in the late 1950s. They were still using the same voting district lines they had back in 1900. Now think about all the people who moved from rural areas to cities over those 60 years. You ended up with dramatically different numbers of people in each district.
Joe Stark.
Our sources highlight this crazy disparity. A rural district with just 500 residents had the same number of representatives as a booming urban district with 5,000. So if you lived in the city, your vote essentially counted for far less.
What's quite remarkable is that the Tennessee state constitution actually required these districts to be redrawn every 10 years to reflect those population shifts. Yet, as the information we have shows, the state legislature simply didn't do it. Decade after decade went by with these outdated and unequal districts.
Right, just ignored it. That's where Charles Baker comes in. He was a voter in Shelby County, that's Memphis, a big urban area, and he felt like his voice was being silenced. He argued that this massive imbalance in representation violated the 14th Amendment's promise of equal protection under the law. Essentially, he said his vote wasn't being treated the same as someone in a much smaller rural district.
A fundamental fairness issue.
And he took that fight all the way to the Supreme Court.
And that's precisely what makes this such a crucial case. Our goal here is to really understand why Charles Baker's challenge became this pivotal moment, why it changed the way federal courts could look at state districting, and, how that initial decision has had this long-lasting impact on so many later battles over voting rights.
So when the Supreme Court took on Baker v. Carr, the core question was this: do federal courts actually have the power to decide if the way a state draws its legislative districts is fair? It sounds simple enough, but as we've discussed, there was a strong tradition of the courts staying out of these matters.
Exactly. Baker's legal team argued that Article 3, Section 2 of the Constitution grants judicial power to all cases arising under this Constitution. They reasoned that Baker's claim of unequal protection, the idea that his vote was being devalued compared to others, directly stemmed from the 14th Amendment and therefore clearly fell under the court's jurisdiction. It wasn't just a political issue, it was a fundamental constitutional question about the equality of citizens.
Okay, so Article 3 gives them the power, and the 14th Amendment provides the right being violated.
That was the argument.
They also made a really important point about what makes something a non-justiciable political question, meaning something the courts shouldn't get involved in. Just because something has to do with politics, they argued, doesn't automatically mean the courts can't rule on it, especially if it involves a potential violation of constitutional rights.
Right. They weren't asking the courts to redraw the district lines themselves. They just wanted the courts to tell the state legislature that it needed to fix the unconstitutional situation.
That's a critical distinction, isn't it? They weren't asking judges to become map makers.
Precisely. They were emphasizing that the judiciary wouldn't be overstepping its role by dictating policy decisions reserved for the legislature. Instead, they would be fulfilling their duty to uphold the Constitution. Furthermore, Baker's side argued that simply because the courts had historically avoided these cases didn't justify continuing that practice, particularly when fundamental rights were at stake.
Right. Past practice doesn't automatically make something right, especially when basic rights are being potentially violated. And let's not forget the core of Baker's argument. The existing system was actively disadvantaging voters in more populous areas, diluting the power of their vote. Plus, the very lawmakers who benefited from this unequal system had shown no interest in fixing it themselves.
Yeah, there's a built-in incentive for the legislature not to act.
Exactly. Now, Tennessee, represented by Joseph Carr, presented a very different argument, focusing on the separation of powers and the principle of state sovereignty. They contended that federal courts lacked the constitutional authority to review how states design their own legislative districts. They argued this was a fundamental power belonging exclusively to the legislative branch of each state.
So Carr was essentially saying, federal courts, mind your own business. This is up to us, the states, to decide.
And they really leaned into that political question idea, highlighting the long history of courts deferring to states on how they organize their elections.
Carr's legal team also argued that the Constitution itself doesn't mandate that state legislative districts have to be perfectly equal in population. They questioned whether there was even a clear objective standard for courts to determine what fairness in districting truly meant. They suggested that if the court started making these kinds of judgments, it would be a move into very uncertain territory.
Like, where do you draw the line? What counts as fair enough?
Exactly. And their final point was a classic one. If the voters in Tennessee were unhappy with how things were, they had the power to change it through the ballot box, voting for different representatives who would then address the issue. They argued that there was no need for the federal courts to intervene. The democratic process should handle it.
Right, let the voters sort it out.
However, the Supreme Court ultimately disagreed. In a landmark 6-2 decision, they sided with Baker, effectively overturning that long-standing precedent established in Colgrove v. Green.
This was a monumental decision. The court declared that federal courts did have the authority to hear cases alleging that state legislative districts violated the Equal Protection Clause of the 14th Amendment. Justice Brennan, writing for the majority, made it clear that a challenge to districts with dramatically different populations did not fall under the political question doctrine in this specific instance.
Now, it's really important to understand that the court in Baker v. Carr didn't actually rule that Tennessee's districts were unconstitutional. They didn't draw any new maps.
Okay.
Instead, they sent the case back to the lower district court to hold a hearing and decide on the actual merits of Baker's claim.
Yeah.
But that initial ruling, the assertion of the federal judiciary's power to even consider these cases, that was the real game changer.
Just opening the courthouse door was the revolution.
You could say that, yes.
And the dissenting justices, Frankfurter and Harlan, were quite vocal in their disagreement. They really emphasized the court's long-standing tradition of staying out of state districting and argued that the Constitution doesn't require strict mathematical equality in state legislative districts. Justice Harlan even warned that this decision would strike deep into the heart of our federal system. Those are strong words expressing a real concern about federal overreach.
They were deeply worried about the judiciary overstepping its proper role and interfering with what they believed were fundamentally state-level decisions about how to organize their governments, a serious federalism concern for them.
But the immediate impact of Baker v. Carr was significant. Our sources tell us that it forced Tennessee and many other states with similarly outdated districts to finally redraw their legislative maps to more accurately reflect where people lived. Urban areas, which had been politically underrepresented for decades, often saw a real increase in their political power.
Yeah, the floodgates kind of opened. By 1966, just a few years after the ruling, a remarkable 46 states had redrawn their legislative districts.
Wow, 46 states. That's huge.
Baker v. Carr truly marked the beginning of a major shift in how the courts viewed redistricting. It established the principle that these issues weren't beyond the reach of federal judicial review when there were credible allegations of constitutional rights violations. The old political question barrier was significantly lowered, at least for this type of claim.
And this foundational principle from Baker v. Carr is what connects it to some later landmark cases, even though those cases dealt with different specific issues. Let's take Brnovich v. Democratic National Committee from 2021. Now, this case wasn't about unequal district populations in Arizona, but about the state's voting policies, specifically their rule about out-of-precinct ballots and their restrictions on ballot collection.
Right, different facts but related principles. The question in Brnovich was whether these policies violated the Voting Rights Act and the 15th Amendment, which prohibits denying or abridging the right to vote based on race.
So what's really interesting is how the core idea from Baker v. Carr, the judiciary's role in ensuring fairness in elections, resonates in Brnovich. In Brnovich, the argument was that these Arizona voting rules, while seemingly neutral, disproportionately burdened minority voters.
Disparate impact.
This echoes Baker's argument that Tennessee's districting system unfairly devalued his vote compared to others, even though the specifics of the unfairness were different population imbalance versus access barrier.
Exactly. Baker focused on the idea of one person, one vote, through equal population in districts, arguing that unequal populations diluted the power of individual votes. Bronovich, on the other hand, focused on ensuring equal access to the ballot for all voters, regardless of race. But in both cases, you have a challenge to a state's election-related rules based on a fundamental principle of fairness and equal treatment under the law.
Something Baker v. Carr opened the door for the courts to consider.
Precisely. And even though the Supreme Court in Bronovich ultimately upheld Arizona's laws, the fact that they even heard the case and analyzed it under the Voting Rights Act demonstrates the ongoing importance of the judiciary's role in overseeing election laws for constitutionality and statutory compliance, a role firmly established by Baker v. Carr. The totality of circumstances test used in Bronovich, while leading to a different outcome, reflects the court's willingness, prompted by the precedent of Baker, to examine the real-world impact of state election rules on voters.
Right. The court is still in the business of looking at these things, even if they reach different conclusions based on the specific law or facts.
Correct.
Okay, let's move on to Shaw v. Reno from 1993. This case involved a challenge to the way congressional districts were drawn in North Carolina. The argument was that one particular district was so strangely shaped, really snaking and non-compact, that it amounted to unconstitutional racial gerrymandering.
Violating the 14th Amendment's Equal Protection Clause because race appeared to be the dominant factor in drawing its boundaries.
Again, the link back to Baker v. Carr is the fundamental principle of a judicial review over the creation of electoral districts and the assertion of a violation of the 14th Amendment's Equal Protection Clause.
Yeah, it's that same constitutional clause, but applied differently. In Shaw, the argument wasn't about unequal population size diluting a vote, like in Baker, but about the discriminatory intent and the use of race as the primary justification for the district's bizarre shape.
Exactly. Baker established that the courts could look at how districts are drawn if it leads to unequal representation in terms of population. Shaw built on that by saying the courts could also scrutinize why districts are drawn in a particular way, especially if race seems to be the overriding and potentially discriminatory factor.
And the Supreme Court's decision in Shaw echoed the underlying principle established in Baker. The court in Shaw once again asserted its power to review the drawing of electoral districts, this time in the context of racial gerrymandering.
So, same basic power, different application.
Correct. While the specific constitutional violation alleged was different from Baker racial discrimination versus unequal population, the core idea that the judiciary can step in when the districting process potentially violates constitutional rights, as established in Baker, was reaffirmed. Our information even mentions Gomillion v. Lightfoot from 1960.
Oh yeah, that case.
It's a case where the court intervened in a situation of discriminatory redrawing of city boundaries, specifically to disenfranchise black voters. This shows that even before Baker, there was some recognition that extreme manipulation of district lines that infringed on fundamental rights could be subject to judicial review. Baker just provided a much broader framework for this principle.
Got it. So Gomillion was maybe a precursor, but Baker really blew the doors open.
That's a fair way to put it.
Finally, let's consider Shelby County v. Holder from 2013. This case challenged the constitutionality of a key part of the Voting Rights Act, Section 5, which required certain states and jurisdictions with a history of voting discrimination to get federal approval pre-clearance before making any changes to their voting laws.
Here, the connection to Baker v. Carr lies in the broader theme of the balance of power between the federal government in Baker, specifically the courts, and in Shelby County, Congress acting under its constitutional authority, and the states when it comes to overseeing elections and protecting voting rights.
Right. While Baker was about the courts asserting their authority to review state districting, Shelby County involved the Supreme Court reviewing the constitutionality of a federal law designed to regulate state voting practices in certain areas. It's still about who gets the final say on election rules, isn't it?
It is. And in Shelby County, even though the court ultimately struck down the formula used to determine which jurisdictions were subject to preclearance, they did so by again exercising their power of judicial review, the same fundamental power over electoral matters that was asserted in Baker v. Carr.
So even when limiting federal power, the court is still using the authority affirmed back in Baker.
It's exactly. The court in Shelby County evaluated whether Congress's actions under the Voting Rights Act were still a justified or congruent and proportional response to current conditions. This demonstrated the judiciary's continued role in overseeing the framework of voting rights, even when it leads to limiting federal power rather than expanding federal court intervention as Baker did.
So looking back at Baker v. Carr, it's clear it wasn't just about fixing those outdated Tennessee districts. It was a really significant turning point. It established this crucial legal principle that the way electoral maps are drawn isn't just a political game. It's subject to constitutional review by the federal courts, especially when there are claims of unequal treatment. The whole one person, one vote idea really stems from this era.
Absolutely. And as we've seen with Brnovich, Shaw, and even Shelby County, the impact of that 1962 decision continues to be felt. While the specific legal arguments and the outcomes in these later cases varied, they all operate within the legal landscape that Baker helped to create the understanding that the judiciary has a vital role to play in ensuring a fair and equal electoral system grounded in constitutional principles.
Which brings us to a final thought for you to consider. Given all the ongoing discussions about voter access, fair representation, and the appropriate role of the courts in our democratic process, how has the legacy of Baker v. Carr really shaped our understanding of what it means for every citizen to have an equal voice in our democracy? It's definitely something to think about as these important legal and political conversations continue.